I'm going to call the meeting to order. Attendance, please.
Supervisor Holdridge,
Here.
Councilmember Becker,
Here.
Councilmember Courtney,
Here.
Councilmember Dysinger,
Here.
Councilmember Ardisana is absent.
Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation,
Under God.
indivisible, with liberty and justice for all. All right. I don't have a prepared agenda for this as we're only talking about one subject and one subject only, the comprehensive plan and zoning, proposed zoning changes. This is a work session that is open to the public but does not include public comments. This is just for the town board to work through our homework for tonight with our town attorney. So Liz, I believe you have materials prepared for the town board and the public to mull over and take it away.
So to facilitate tonight's work session, what I have done is I've made a presentation given the concern over changes to the AR3 zoning district. I have also, so that will be the first part of the discussion, and I will go over some history, some rationale, and explain that. The second part is going to be a discussion. A number of issues were raised in comment, some by public comment, some by, we just received our County 239 review, so there's some things in that letter I'd like to address with the board, as well as other issues. And just remember that both the comprehensive plan and zoning amendments are living, breathing documents. They're intended to be changed and evaluated over time. So I anticipate, based on our discussions that we've had, that there will be future revisions in the future. There's a long list of goals in the comprehensive plan. We've tried to tackle some of the most pressing, but certainly there is more work to be done, and it is a constant evolution. Okay.
Before you get into it, I just want to remind the public that this is a work session, so we're not accepting public comment tonight. But I understand that that's not going to stop you guys from having comments and questions. So if there is something that you do have feelings or questions about, please feel free to take note of it and email the town board after the fact, and we will try to get back to you if it's necessary to later on. But tonight, this is a work session for the town board. I've been told that we can't have public comment tonight. So
well, I'd like to get through.
Yes.
Get through this and get the input from the town board, so I have direction as to
Yes.
finalizing the zoning and comp plan. Okay.
Take it away.
So goals in preparing, and I'll try not to read too much. The goals in preparing the zoning amendments, first and foremost, was to implement many of the goals in the draft comprehensive plan. I did go through and try to count. The proposed zoning amendments touch upon 26 of the stated goals set forth in the proposed implementation schedule of the draft comprehensive plan. And I just want to reiterate to the public that the plan right now is in draft form, as is the zoning. Often what happens is a comprehensive plan is adopted. That's great. We have all these warm and fuzzies, and then nobody does anything for 18 months, 2 years. So I'm a big proponent of doing them simultaneously and having a simultaneous seeker review. So you do the seeker on both documents. You adopt the comprehensive plan first, and then you adopt the zoning. That way you're immediately implementing at least some of the goals in the comprehensive plan. I have seen some great comprehensive plans, and then nothing happens for 2-3 years, and they have applicants coming in for projects that are inconsistent with the plan, but they meet the zoning because they haven't updated the zoning. Bring the zoning code, particularly the application processes, in line with the New York State enabling statutes and with New York State case law. Zoning, the planning board and the town of Chester gets its authority from zoning through New York town law, which comes down from the state. There's a similar provision in village law that establishes that, one, authorizes you to have a planning board, two, authorizes applications such as subdivisions, special use permits, and site plans. The current zoning code kind of blended them all together, even though they're three very different applications. And in fact, your code did not have a special permit process. And I'll get into that in a little bit, get into that in greater detail a little bit later on. We also were attempting to go through and reconcile inconsistencies within the zoning code. The bulk table says one thing, the text of the zoning code says another. We try to the best we can to find all of those. I will tell you, of 16 years of doing this, there's a rule: you adopt it, you will find one. We always find them, but we try to the greatest extent we can to find those inconsistencies and to reconcile those inconsistencies. Okay, so I wanted to jump right into the history of the AR3, schools and religious institutions. Prior to 2017, schools and religious institutions were permitted in the AR3 as permitted use, subject to site plan.
Can you just explain what AR3 is to those who don't understand?
That is your agricultural residential zoning district.
And the 3?
Is generally refers to 3 acres.
Okay.
Okay, I could call it the agricultural residential. It's essentially the short term.
Yes.
But it was permitted, subject to site plan. There were specific requirements set forth in section 98-29 of the zoning code. In September of 2015, the town adopted the 2015 comprehensive plan updates. The plan recognized 3 goals in relation to Camp Monroe. On page 43, it recognized that the 2003 comp plan recommended acquiring for a town park. On page 47, it recommended extend the Highlands Trail through Camp Monroe properties through public-private partnership to provide a direct connection to the Appalachian Trail. And on page 95, wrote clustering, conservation easements, or incentive zoning are all tools that could be considered to preserve a portion of Camp Monroe as parkland. So those were the goals that I found in the 2015 comprehensive plan updates. So, and this is your old, this is, again, I said prior to 2017, this, and I apologize, it's blurry. I was taking this from a photocopy. This is the bulk table that was in existence prior to that 2017 local law. The 2 I've highlighted, the top one is, and I'll read it, a church or similar place of worship, parish house, seminaries, convents, dormitories, and related uses as per 98-29. And then down below, school, private schools, college, or other educational institutions per 98-29. So that was in your code.
That was in our code up until 2017.
Yeah. In 2017, the town board adopted local law 1 of 2017 on September 27, 2017. I copied here the legislative intent. Often local laws provide their purpose up front. I did abbreviate it because it was fairly long and touched upon solar, and that's not really relevant for the discussion. So I did cut that part out for this slide, but you can see it. It's a matter of public record. This local law is intended to protect the public health, safety, and welfare of the community by implementing certain recommendations of the Town of Chester's 2015 comprehensive plan. It is further intended to protect property values, protect the physical appearance of the community, preserve the scenic and natural beauty, and to ensure that certain non-residential uses are situated within those areas of the town with infrastructure to support them. It goes on, this local law strengthens the special permit requirements for religious institutions and schools to balance the potential impacts on neighbors and local roadways, while ensuring ample opportunities to situate these institutions within the town. So that was the stated legislative purpose. So what did local law 1 of 2017 do? And I will preface before I get into this, it was really 2 parts. There was a big chunk attributed to solar. I'm not going to talk about the solar because that wasn't really at issue as part of this discussion. So my focus is really on the AR3 and the religious uses component of it. So the local law eliminated religious uses in schools outright in the entire AR3 zoning district. The AR3 zoning district represents about 70% of your land masses. And that's despite the fact that the comprehensive plan, and this is the 2015 plan, did not discuss treatment of religious uses. It did rezone portions of Camp Monroe from SR2 to AR3. SR2 is suburban residential on smaller lots. So it put the entirety of Camp Monroe into AR3. By doing that, it prohibited existing religious institutions, including the Bruderhof community, as non-conforming. Okay, so where the Bruderhof community seek to expand under a strict application of the zoning, and I say that with a big caveat because I'm going to get to the law later. But if this was a use, a non-conforming use, generally they are severely restricted in expanding because your goal is to eliminate non-conforming uses over time.
So that right now, as
The
is.
Bruderhof is technically, but again, that's with a very large caveat, which I'll explain in a few minutes.
And to those of you who don't know, the Bruderhof community is the Balevale community off of Gibson Hill Road. Just so everybody understands.
It also eliminated daycare centers, nursery schools, and annual membership clubs providing outdoor recreational activities. It did retain excavation and removing of soil. So it retained mining as a permitted use in the AR3. Okay. What did Local Law 1 of 2017 not do? It did not implement any goal of the 2015 comprehensive plan as they related to Camp Monroe. So remember I said that the 2015 comprehensive plan brought up tools such as clustering, incentive zoning, conservation easements as ways of preserving open space. And they did not, this local law didn't even touch upon any of those potential tools that are available to it. The 2015 comprehensive plan, again, I went through that document, word searched it, did not make any recommendations regarding religious use in any zone. Notably, and I was very surprised to see this, Linda and I did take time to go through the historic files because I know how important this is to the town. So we wanted to see the historical context of what happened. The Local Law 1 of 2017 did not undergo a seeker review. They said,
Can you explain what seeker is?
so seeker is the environmental quality review that's required when a town takes an action, whether it's a planning board approving an application, this board in improving a local law, comp plan, we all have to undergo some level of seeker review. The Local Law 1 of 2017, what I can gather from the record, again, reviewing the record, is it looks like they said, oh, wait, we did seeker for the 2015 comp plan changes, so we're going to rely on that seeker. And normally that's fine. Unfortunately, they also didn't do seeker for the 2015 plan. There was no vote for either document. So there was no findings. There was no, usually when you go through the process, there's two potential paths. The first path is on smaller projects or projects where you say, you go through and we have a whole checklist that we can go through. If you look on the New York State DEC website, it's the Part 2 form. There's a environmental assessment form, which is our starting point, and then we build on that. The Part 2 is this great big long checklist where we go through and we either say there's going to be no to small impact or there's going to be a moderate to large impact. If everything is no to small impact, you know, we've gone through, we've taken a look, and we don't think there's going to be a big impact. Usually these are small things. A new use coming into an existing space. They're not doing much to change the site. They're just taking over the space. Likely not a lot of impacts. In other instances, there will be a larger impact. So when all the answers to that are no to small impact, we adopted what's called a negative declaration. There's no environmental impact. If we identify any potentially moderate to large impact, we then focus on that moderate to large impact. We look at, if it's a project, we look at the project. What is the project doing to mitigate that impact? So I'll give you an example. Maybe it's traffic. There's a traffic concern. There's too much traffic. And the applicant says, you know what? I'm going to put in a traffic light. That will mitigate the traffic impact from this project. So then you can then go, the impact is mitigated by the traffic light. That's a reasonable mitigation, and adopt a negative declaration. Sometimes on very large projects, we say, this is a big one. I have one right now in Monroe, which is undergoing a big one. And you do an environmental impact statement where there's a number of large issues, and you study those issues. And you issue what's called a positive declaration. Yes, this project will result in an impact. Then the applicant has to study those impacts and say how the project is addressing those impacts. And at the end of the day, you issue a finding statement. So at the end of the day, you either have a negative declaration or a finding statement. The board has to vote on it. It's a written document. There has to be a vote. And in this case, there was neither a negative impact or a finding statement for either the Local Law 1 of 2017 or the 2015 comprehensive plan. It also did not establish a special, remember I said that the local law 1 of 2017, the legislative intent was to strengthen the special permit for related to religious uses, except it didn't establish a special permit process. So there's nothing in the code that tells you how or what the standards are, whoops, excuse me, to get that special permit. All right, doesn't give you the standards to evaluate the special permit.
Can
Right.
you explain what a special permit?
I'm getting it.
Just want people to be on the same page.
Every once in a while, you have to trust me. I'll get.
My best.
Okay. All right. So I'll get to special permit in a couple minutes. So I want to jump to legal authority. All right. A lot of people have heard the word RLUIPA. That's the big one. What a lot of people haven't heard about is the New York State rule. And I want to address both. I'm going to start with the New York State rule because I actually think it has greater impact than RLUIPA does. And the New York State rule is far older than RLUIPA. RLUIPA was adopted by Congress in 2000. The New York State rule goes back to at least the 50s. So I want to explain that. Okay. So we're starting with the New York State, the state rule. So I'm just going to read this, and this is where I turn a little geeky and land usey. So bear with me. I'll try to get through this. The law is well settled that religious and educational institutions, so they do the treatment, even if it's not a religious school, it's a private school that doesn't have any religious base, that's similarly treated. So that's why both religious institutions and schools are treated similarly. So the New York rule applies to both. I just want to be clear. Okay. Enjoy special treatment with respect to residential zoning ordinances because these institutions presumptively serve the public's welfare and morals. The big case that a lot of folks rely on is in Cornell University v. Bagnardi. This is a Court of Appeals case, and in New York, Court of Appeals is the highest court. It's the equivalent of our Supreme Court. The New York Court of Appeals wrote, the total exclusion of educational and religious institutions from a residential district serves no end that is reasonably related to the morals, health, welfare, and safety of the community. Since a municipality's power to regulate land use is derived solely from its rights to use its police powers to promote these goals, such total exclusion is beyond the scope of a locality zoning ordinance. I've also provided in here some of the older sites from the 60s and 50s. Again, all these cases predate RLUIPA. Okay. In addition, as part of the New York holding, cases where they treat a religious use different from a commercial use, those are often viewed with suspicion. Both the cases I've cited here, Jewish Reconstructionist Synagogue and then Apostolic Holiness Church, both of those provided different standards. So they had setbacks. So setbacks is the spacing between a property line and the physical building. And we try to have setbacks to regulate so that we have a nice even, you don't want houses in some neighborhoods right up on the street, things like that, too close to the neighbors. A commercial use could seek a variance through the ZBA, and a variance is a application process where they can request a smaller setback because of hardship. And but the religious uses had to meet the setback. Come heck or high water, I won't use the other word. Come heck or high water, they had to meet the setback. And both those cases, the court said that's an improper distinguish and was suspect. RLUIPA, this is the federal statute, again, and this is what most people hear about. This is what most of the talking points are on with respect to religious uses. Okay. Now going through, I could stop at the New York, my recommendation to the town board with respect to how the zoning is drafted. I could stop at the New York rule. RLUIPA certainly influences our decision and how we do it, and is certainly a federal backstop. The big issue with RLUIPA is where there's a violation, it does provide for a right of action as well as attorney's fees and things like that, if a entity were to prevail under Ray Lupa. So does this mean religious uses and educational uses have carte blanche? No. Okay. The Bagnardi case explicitly rejected any argument that appropriate restrictions may never be imposed with respect to a church and school and accessory uses. Okay, and that's a little bit of, the court gave you a double negative. That's a quote. It's a double negative. So what the court's saying is just because you can't prohibit religious uses in a residential zone, you can still regulate them. Okay. It went on to find that the beneficial effect of a community can be rebutted with evidence of a significant impact on traffic congestion, property values, municipal services, and the like. So the presumption, there is a presumption that religious and school uses are beneficial and that they should belong in a residential zone. This is longstanding because typically you'd have a residential community, the church would be there, the local folks would go to their church nearby, and it would be part of their community. Okay, that presumption can be rebutted. Okay, in Pine Knolls Alliance Church, and again, this is the Court of Appeals, so the highest court of New York, we have invalidated ordinances that impose blanket bans on religious or educational uses in particular communities in favor of a case-by-case review, and the court specifically endorsed the special use permit application process as the proper procedure for addressing expansion requests. This procedure affords the zoning boards, and that could be the planning board, that could be in some instances the town board, maybe the ZBA, the zoning board of appeals, most likely your planning board, an opportunity to weigh the proposed use in relation to the neighboring land uses and to cushion any adverse effects by the imposition, of conditions designed to mitigate them. In that case, there was a ZBA for a specific, a church wanted to go in, and they asked for a secondary driveway. And the ZBA said there was a traffic issue with that secondary driveway, and they said, you can have your church, you can't have your secondary driveway. The court upheld that determination. Okay. So what does all this mean for the town of Chester? The proposed zoning amendments seek to implement an individualized approach endorsed by the courts. So that special permit approach that the courts have endorsed versus a blanket prohibition, which we know the courts have rejected repeatedly. Each and every religious and school use townwide for expansions and new would undergo, if the current zoning was adopted, a special permit. And I'll get into special permits. They'd undergo a site plan, and they'd undergo a site-specific seeker review. And again, that's that environmental review. That's where they have to address the potential impacts of a project. Traffic, do they have enough sewer water capacity? Wetlands on site, all sorts of issues that can be raised. It's through this process that sites such as Camp Monroe will undergo that individualized environmental review. And again, I went through all those impacts. And again, it can be a wide, seeker is a very broad, and you can identify any number of impacts, okay? In the village of Monroe, we have recently had an application come before us that went through a fairly lengthy process under a special permit procedure. The Monroe Woodbury Islamic Center. That project underwent a fairly significant I think they were before us for like 18 months, going through that process, discussing parking, drainage, noise, all sorts of things. And that organization worked with the village through the planning process to mitigate as many of those impacts as they could, and ultimately got approval with conditions. Supervisor beat me to it, but so now I'm getting to the what's a special permit. Okay. A special use permit is a specific permit. Its authority is found in 274B of the town law. It's an authorization of a particular land use which is permitted in the zoning ordinance or local law, subject to requirements imposed by such zoning ordinance or local law. to assure that the proposed use is in harmony with such zoning ordinance or local law and will not adversely affect the neighborhood if such requirements are met. The town law further authorizes a board to impose reasonable conditions and restrictions on a permitted use. Okay. So I will get into that. And again, just going back to, did I go the right way? Yes. Going back to that, that special permit procedure affords those planning boards, zoning boards, an opportunity to weigh the proposed use in relation to the neighborhood. There are probably places in this town where a religious use, or any use for that matter, is inappropriate. You can't put it in the middle of a wetland. That's inappropriate. There are places where it is more appropriate than others. So we want to get to this specific case-by-case basis. In Trustees v. Union College, they wrote, and I think this is really important for folks to understand, zoning officials may conclude that a particular educational or religious use may actually detract from the public's health, safety, and welfare or morals, and may deny a special use permit on that basis. When the negative impacts are not so extreme as to warrant outright denial, mitigating conditions may be imposed to ameliorate the harm, provided they do not, by their cost, magnitude, or volume, operate indirectly to exclude such use altogether. Okay. So again, you can deny it. The question is, what's the impact? What's the actual impact? Is it traffic? Is it noise? Is it sewer water? Okay. Is there a way to solve that impact? If there's a way to solve that impact, then you make that solution be a condition of your approval. If there isn't a way to solve it, then that's a basis to deny the project. Okay. The proposed zoning amendments. I want to draw everyone's attention to section 98-31, which adds that special use permit application process. This did not exist prior to this draft. Your code made limited reference. I did a word search and there were 6 references, but they were kind of floating references, which tells me that at some point in time, and this happens in municipalities all over the place, folks say, oh, that's a great idea. The town of such and such does that. We're going to copy their code. So they copy their code, but they only copy part of it, or they miss a piece of it. So part of that special permit, and this is in the draft language of the code. So I've copied all of these and I'm going to go through them. The planning board must determine the following objectives can be met, and they have to make these findings, okay? The proposed use shall be deemed to be compatible with adjoining properties and with the natural and built environment of its surrounds. The site is accessible to fire, police, and other emergency vehicles. That's a big one. Someone proposes whatever they propose, and I can't get a fire truck to it, we're gonna have a discussion. We're gonna have to find something, an alternative location if I can't get a truck to it, okay? The use is suitable to its site upon consideration of its scale, intensity in relation to environmentally sensitive features, including but not limited to steep slopes, floodplains, wetlands, and watercourses. Adequate screening and separation distances are provided to buffer the use from adjacent properties where the authorized board deems it necessary. The use will not negatively impact ambient noise levels, generate excess dust or odors, release pollutants, generate glare, or cause other nuisances. Parking shall be sufficient so as to not create a nuisance or traffic hazard on adjacent properties or roads. Vehicular, pedestrian, and bicycle circulation, including levels of service and roadway geometry, shall be safe and adequate to serve the use. The location, arrangement, size, operation, including hours of operation, the design of the use, including all principal and accessory structures associated with the same, shall be compatible with the character of the neighborhood in which it is situated and shall not hinder or negatively impact the use, enjoyment, or operation of adjacent properties and uses. Utilities, including stormwater, wastewater, water supply, solid waste disposal, and snow removal storage areas shall be adequate to serve the use. So those are findings that the planning board has to make. And that applies not just to religious uses, but any use. If you look at the bulk tables, one thing your prior code does, or your current code does not do, is identify which uses are actually special permit uses. If you look at the bulk table, any use that has an SUP, that is a special permit use. The planning board has to make those findings for anything that's designated an SUP on the bulk tables, okay? And again, this didn't exist before this draft. I mentioned that one. In addition, some of the SUP uses have very specific standards. Some of these are carryovers. We've added, modified, supplemented. If you look at 9829, you'll see specific restrictions for each, for certain designated uses. We have added things to the religious institutions as well as the schools of general instruction. And again, the reason we have these criteria are for, the intent is to address and mitigate potential impacts. We did, again, we got our referral from the Orange County Department of Planning, which is a required step in this. And they found this approach to be appropriate. And I'm gonna, give me 1 second. A couple of things I want to point out in the religious uses. Some of this is carryover from your existing code, but we have added some language. One of the big things we have added for services, and we all know this all happens with any religion, big events. You know that the church on Christmas is going to have cars down the street. This requires a plan to be submitted to PD when they anticipate they're going to exceed their parking lot capacity, how they're going to, if they need to shuttle people to the site. And again, that applies to all religious institutions. I want to be clear. There's some additional screening, sewer water requirements, okay, treatment of accessory uses, okay, and also often some religious institutions have a school associated. They might have an elementary school attached. I know the church I went to growing up as a kid had a K through 5 school attached to literally physically attached to the church. If that is the case, they need to have enough land to accommodate both the church and the school. So they can't just say, oh, we have one lot. They have to make sure they have enough acreage to cover both. So those are there to intend to mitigate. And again, if an impact is identified, the planning board now has the flexibility and authority to issue a condition to work against mitigating that. Okay. The other thing that special permits have that site plans do not is they actually have a renewal provision. Planning boards have the authority to issue a clock on them. And what that means, and what the boards I work with typically use it for, is a way to, as a check on the property owner. And again, this applies to all special permits. Are they doing what they're supposed to do under the permit? And if they're not, their special permit doesn't get renewed. So that gives us a fairly large carrot, because they know that usually it's 3 years, maybe 5, they're going to have to come back to us and get that renewal. And if they're not doing what they promised that they do as part of the approval, they run the risk of losing their special permit.
Have they have to do that every 5 years?
It depends on what the board sets it at. I had the ShopRite in Monroe. They have to come to us. I think they're every 3, but every 3 years we go, that planting isn't looking good. You want your renewal? Go fix that planting up. Go clean up that parking lot. Go fix that dumpster enclosure. It gives us that chance to kind of ratchet them back in.
This is up to the building department to get this done?
No, that would be a
The
planning board.
Planning board?
Renewal is a planning board. Okay. I do want to point out, there's been a lot of discussion about preservation of open space, and I know it's really important to this town. So I want to just give you some other tools in your comprehensive plan and zoning amendments that the town has at its disposal for that open space.
Before if I may, can I?
You're killing me, but okay.
I just wanted to so for everything with special use, that for religious special use permits for religious use in the AR3. We're not just talking about one property here. We're talking about all of AR3.
The entire town.
The entire town.
Any religious use, no matter what district it is designated as a special use.
Got it. And with that, with all these sort of, I guess I think what people might be afraid of is an idea that you may be setting up all these regulations, all these hoops. But what does it really come down to when in terms of enforcing it, and how do we make sure that all of those check marks are actually being followed before, during, or after an application is put forward to the planning board.
So my recommendation to the town is always good approvals make easier code enforcement. So there's what can be approved under your zoning code, and then code enforcement. This is where, and this is a tool for the planning board, and you've got good planning board counsel. There is nothing more aggravating when I get motion to grant the application. Okay, what does that mean? What's in there? What are we approving? Which plan set are we approving? We've seen 3 plan sets. Good approvals with detailed resolutions, with detailed conditions, right? Make for easier enforcement because it's black and white. Your approval that was granted on such and such date says that as a condition of your approval, you had to do X. It's in writing. It's in your approval. It's filed. It's with the
Site plan.
it's with the site plan filed with the building department, and the approvals filed with the clerk's office. And there's no question. There's nothing worse than when I get a vague approval and you go, well, the approval didn't say anything about that. What do I enforce? Were you authorized to do that? You weren't prohibited from doing it. So it puts us in it. So my recommendation is always work with your planning board. Your planning boards and ZBAs should be getting, they are required to go get regular training. They have their credits that they are required to get. I am happy to give any sort of training, Dominic as well, and I'm sure you have, Dominic Cordisco is your planning board counsel, Elise Terhune is your ZBA counsel. We have these discussions all the time with how do you make code enforcement stronger?
Does any part of these amendments or part of the plan, or is it separate in terms of possibly beefing up the penalties for non-compliance, or for the attitude of build first and ask for permission later?
Well, I certainly recommend, and I have recommended in the past, many municipalities in Orange County use a after the fact permit fee. So if you go to legalize work that was done without a permit, it's double the cost. So I encourage you to consider that. There are other provisions, but also a lot of our code enforcement. Remember, code enforcement typically, and your code does have this, it's a per day fine. So you construct something without. It's not like a speeding ticket where you sped once and it's a one-time fine. You build something or you're operating. Every day that it continues can be charged as an additional day. Not that I have seen it, but the law does authorize up to 15 days in jail.
And what if, and I apologize.
You're killing me. I had this beautiful flow. It's all good.
I feel like I know the sense of some of the, what you may call laymen out there in the public. The attitude not only of build first and ask for forgiveness later, but the money that it takes to solve a non-conforming use or a building that was put up before approval that is not in compliance with our code or with our law. What are the attitude of it's just nuisance value to pay that off? We're going to get our building up, or we're going to get our whatever up anyway. What happens? What do we already have in our code, and can we not put more into our code to make sure that stuff that goes up that's not supposed to be going up and does not get approved gets torn down and set back to a status
Well,
quo?
there is language. We did add language, and you have to be careful. And I actually just had this conversation with Attorney Terhune about this. I did add language to the special permit section that they don't get a special permit if there's a violation on the property. Now, sometimes the site plan or special permit is rectifying the violation. And so you have to be careful there. But there are ways, and again, it's just, you have to have a proactive building department, right? You just, code enforcement is tough, but it's doable. You have to have a very proactive building department to start that. Like, for example, I, as your town attorney, can't initiate a complaint. Andrew, as your code enforcement, Contarino, as your code enforcement officer, is the one that initiates the complaint. I usually get a, hey, Liz, we've got a problem. We need to go for it.
But I got a question on
Sure.
that. How does that get initiated? Because I get the feeling from most of the dealings I've had with building departments, they're not going to initiate anything unless a written complaint goes in.
It
So
depends
that's where
broadly on the, it depends broadly on the department. Legally, if the building inspector, in my experience, the vast majority of cases are initiated because someone sees something and files a complaint.
Mhm.
So-and-so's doing something.
That's
Okay.
that's an issue I've always
Yeah.
had with variances, because people get variances, they do things, they're non-conforming.
Well, variances are different.
Yeah,
Variances
well,
are legal.
Yeah, they're legal, but when they
Variances are,
violate that variance, again, it comes down to, the building department doesn't go out and look at these things.
so the vast
That's
majority
22.
are, somebody sees something, files a complaint with the building inspector goes out, investigates it, and goes, yep, that's a violation, issues a notice of violation. And the first step is to issue an order to remedy. If you issue that, the order to remedy catches what I call the mea culpa. Usually those are very small level, I didn't know I needed a building permit for this type thing. Usually, I'll use one that comes across my desk all the time. I didn't know I needed a building permit for a deck. Okay. It's a violation, not a, oh my God, violation, but it's a violation. They ordered a remedy, people get it. And the good folks go, oh shoot. And they come running into the building department. I'm so sorry. Here's my permit. Get it inspected, fix it if they need to fix it, but close it out. Other times it's significantly larger.
But as far as the building inspector goes, with our codes and everything else, is it allowable for him to set violations from him viewing things
Yes.
without a,
He does not need a complaint if he observes it.
okay,
He does not need a complaint if he observes it.
Okay.
Most times, even if he gets a complaint, he should go and observe it himself. Because look, we get lots of complaints. I have one in Florida right now. Two neighbors hate each other. It's Hatfields and McCoys. They call the building department. They did this. They did this. They did this. And we're like, okay, guys. I do recommend my building inspectors, to all my building inspectors, that they go personally observe it.
Okay, thank you.
We did have some success with the farm
Yeah.
up off of Route 94. We were able to stop that. It took some effort, but we did have some success there. Okay, so I wanted to go back to tools in your comprehensive plan in the draft. Again, these are drafts. Enhancements to the cluster regulations, where proposed development is clustered away from environmentally constrained lands and to preserve open space. We actually have a great example of this that we just signed off on, and the supervisor signed the paperwork yesterday, and I'm filing it as we speak. Oakwood subdivision, which actually adjoins Camp Monroe. It's
It's the property on Camp Monroe Road to the left. From
Okay.
yeah, I spoke.
so
to
as that applicant came before us, I believe it's a 4-lot subdivision on 26 acres.
yes.
They took the lots, they smushed them to one side of the 26 acres, and they gave us, the town of Chester, the other 13.
So we preserved 13 acres of land for the town of Chester. It will
So
be
we now
town-owned
own it.
Yes.
One of the recommendations which is actually in progress, is the establishment of a community preservation fund. There was a big announcement on this. Governor Hochul signed this on October 17th, 2025. We do have to put this up for a permissive referendum, and that'll be in 2026.
It's permissive.
No, it's referendum, just referendum. I'm sorry.
Got my hopes up.
Sorry. But other communities have that. Warwick is the prime example here in Orange County. They collect 0.75% of the purchase price as a transfer tax on buyers coming into Chester. And then those funds are put into the Community Preservation Fund and utilized to buy open space or other areas. Warwick has used it for what now, 20 plus years?
Yeah.
They
Right.
preserve over 5,000 acres of land with the Community Preservation Fund.
And some of that's historic, some of that's open space designated. And the other thing they can do is you can separate development rights from the land itself. And they often do this with farmland. So the farmers who have, and it's a great agricultural preservation technique, the farmer gets some money. And rather than, because what used to happen is farmers would have their, and I'm using a round number, 100-acre plot. They needed some money. They'd subdivide off 5 acres, sell that 5 acres. Now they got a pile of money. A couple years later, they'd subdivide another 5 acres. Or when they really needed a lot of money, they'd subdivide the whole 100 acres. Now what they can do is what's called PDR, Preservation of Development Rights. They separate the development rights. The farmer gets some money from the Community Preservation Fund. They still own the property. They can sell it at the end of the day if they want to, but they can't. There's limited development. They usually allow, and I do have a client that is on PDR property. They usually allow the agricultural stuff to stay as part of the development, and they allow a home site. So they allow one home site and then the rest of the farm. I helped a client with that off of Sanfordville Road in the town of Warwick. Okay, so that is in process. That's going to take some time to develop because we need to. The money doesn't magically appear, but that the town has been asking for that for years.
For 6 years, and we just got it approved this year. So it's a huge
So
achievement.
we now have to go through the process to let the voters say, yes, we want this. We hope you do. But that at least we're one very large step closer. We tried to strengthen ridgeline protection requirements. You do have an overlay for your ridgelines by adding language for the visual impact analysis. We eliminated excavation and removal of soil as permitted use. Okay, no more mining. Okay, and that was a goal. And then we also tried to provide, to encourage the agriculture, which is a big tenet of your comprehensive plan. We've tried to increase with greater flexibility the agricultural uses in the form of agritourism to diversify farm income and to encourage farming within the town. So we really put a focus on that. Okay, I'm gonna go to Camp Monroe. Just because I've been spending the past couple of weeks going through the public comment, hearing the public comment, and I want to lay it all out there so everybody has the same source of information. There is no site-specific zoning amendment for Camp Monroe. This relates to the entire town and the entire AR3 district. Camp Monroe representatives did not participate in the drafting of the text of the zoning code. Okay, they did provide public comment. That public comment is a matter of public record. You can see what they have submitted. But they did not assist us in any way prior to the draft being introduced. There is no proposal currently submitted to the town for future expansion. Okay, we do not have any, we are not aware of any development plans beyond what is existing on site. Okay. I want to be clear that the existing seasonal camp operates as a pre-existing non-conforming use, which means it's been around longer than zoning. Okay, so it didn't get site plan approval. It didn't get a special use permit because those things didn't exist when the camp started. That camp's been there since, you guys know better than I do, but it predates zoning. Okay. Remember when I said great approvals make for easier code enforcement? Well, how do you enforce a code when you don't have an underlying approval that says what you can and cannot do? One of those biggies is what's seasonal? Is seasonal June to September? Is it April to October? What is it? There's no document in the town that says what seasonal is. Okay. Trust me, I've looked, I have gone through the boxes and boxes and boxes of every document that even says Camp Monroe, I promise. Okay. This use would continue as a non-conforming use. Any non-conforming uses are permitted to continue unless they are abandoned. Okay. even if we didn't adopt these changes, okay, that use would be permitted to continue. I want to be clear, and this just is not just Camp Monroe, but Camp Monroe, as with any property, can be redeveloped into other uses permitted under the zoning code, including year-round uses. I did look, some folks that said, wait, there were restrictions. We did go through the land records. There do not appear to be any restrictive covenants restricting the use of that specific property. There is again, the conveyance to the town of Chester, and I'll explain that in a second. Also, even if there were deed restrictions, the town does not have standing to enforce those private deed restrictions. If it is a condition of an approval, and often many of our approvals are, we say, you have to file a declaration on the land records for these issues. I do it all the time, where, a condition of approval, Warwick even has their standard declarations. You recognize you're in farm country, it's gonna, we have to record those restrictions as a condition of the approval. And then the town would have standing to enforce them. But if it's just a buyer and a seller unrelated to the town, we would not have standing to enforce those deed restrictions. They don't exist. I did look. Okay. Any change to the use or layout of Camp Monroe will require a site plan, special use permit, and site-specific seeker review. In addition, buildings would need to be brought up to current New York State Building Code. The vast majority of the buildings on that site are not constructed for year-round occupancy. Okay, they are unwinter. They don't have heat. They don't. They have to be shut down. It doesn't work. So there would need to be a fair amount of construction, and they would have to come up to New York State Code. I do want to be clear. If they need to replace a roof as part of maintenance, that would be permitted as part of they're allowed to maintain the buildings, and as you would maintain buildings. Okay. Okay. I pulled up a map of the Camp Monroe area. Can you see my cursor does work. So this is Camp Monroe. And I just wanted folks to get a sense. This piece was conveyed to the town of Chester. There was a subdivision, I believe it was 2015. And during that time frame, there was a subdivision. This 29 acres used to be part of Camp Monroe. It was conveyed to the town of Chester as open space. You will see there's this funny little path. This connects us, I believe that's Wilson Park. Is that correct?
Lake Hill
Lake
Farm.
Hill Farms.
Lake Hill Farms.
We own that.
And this is all owned by the town. So you have a piece connected here and a piece connected here under town ownership. This long, complicated piece, that's Con Ed. That ain't going anywhere. That's Con Ed. This piece is off the New York, New Jersey Trail Conference and is part of the trail system. And then lastly, this piece over here, this is roughly the 13 acres. It's not filed yet, so it's not shown as its own lot because we literally just signed the documents.
Can you move your cursor to the road up there? That is Camp Monroe Road for all of you guys, if you can see it. That road right there where her cursor is, that
Michelle,
she's moving it.
Can you just point right there?
If you look at 23.21.
Yep, up here. That's
and
Camp
go
Monroe.
up to 24.2, the road right in there.
That's
Okay.
Camp Monroe Road.
Yeah.
The road traveling north is Trout Brook. That's all Sunfish and Pickerel up there on the top right.
Yep.
Down to the south is Lake Hill Farms, and then so on and so forth. The giant piece in the middle, 27.42.
That's Camp Monroe.
That is Camp Monroe. Just so
Okay.
you guys have an idea. So basically, what Liz I think is trying to show is that the property is surrounded by utility property and town property at this point.
They can't expand.
There's no.
Physical expansion is unlikely given these parameters. So this is Lake Hill Farms. So this is town-owned property, and this piece is also town-owned property. I think there's utilities there.
Yes.
Sewer,
Water.
The dam
Water.
or something.
water,
The pump station.
pump station. Where?
What?
This is Lake Hill Farm.
That's Wilson Drive, I think. Or
Wilson.
Road.
Wilton Road.
Yeah.
So I just wanted to like give you a broader sense. So they're kind of surrounded on all sides. So this is not a site that can creep out. And part of that is the long-term planning of, you know, your long-term goals of increasing this. And you've slowly but surely been gathering pieces. The town has been gathering pieces, and they're pretty darn close to connecting all those pieces of open space. Okay. The next slide, this is a terrible copy, and I apologize. This is taken from the Camp Monroe subdivision. I'm going to stand up because it'll just be easier. This is taken from the Camp Monroe subdivision. This piece here, this parcel C, is what was conveyed to the town. Okay. The gray shaded area, that is in your ridgeline overlay zone. The other gray area is your floodplain overlay zone. So those are more restrictive zones. Okay. The proposed amendments actually do not alter those in any way, shape, or form. Okay. And the religious uses, the fact that it's a religious use wouldn't be impacted. Remember, I said you can't put a church in the middle of a wetland. Like you can't put anything in the middle of a wetland. So those provisions are still, those restrictions are still there. So I just wanted folks to get a better context of that actual site. Okay. So just as a quick summary, because I've hit the end of the presentation part, and I'm going to now go into the working part with the board to get some direction from the board. The New York law is very clear. It's been upheld from as early as the 50s and is repeatedly reaffirmed that religious uses, we need to include religious uses in residential zoning districts, which the AR3 is a residential zoning district. With that said, there are ways we can regulate it, and we have worked very hard at implementing provisions to provide appropriate regulations to address the actual impacts. Okay, fly, go away. To address the actual impacts. Religious institutions, schools do not just get carte blanche. And we have really tried to address that, fill that gap that existed in your code. So that's, I hope.
Carte blanche meaning they can't do everything they want to do.
They can't just come in and say, we're a church, we get to do whatever we want. No. They still have to go through seeker review, and those impacts have to be addressed. They don't have adequate sewer and water. Sorry, you're not getting your institution, whatever that institution may be. So traffic is a huge one. Again, I'm a big, they got to comply with the building code. And that's not the town of Chester. The building code's New York State Uniform Code. That's a lot of times where we have enforcement success because remember, religious institutions and schools also fall under assemblies. So they have to meet assembly standards for fire, depending on size, sprinklering, fire access, all that. Those are areas where we do have some enforcement success, because you want to make sure that somebody can get out of the building if there's a fire. So those are areas that we do have a lot of success. So I've tried to put that together. I will be emailing this presentation to Linda. It will be on Linda. You can add it to the website for folks to see. The rest of the purpose of the meeting, the rest of this meeting is I have some questions, policy decisions for the board on a wide variety of topics. I'm going to go through those. My next sets of slides are not very fancy. You'll see. That's pretty, simplistic. So the pretty slides are done. In addition, we've received all the comment. The public comment period is closed. My office is working through those public comments. We are providing a written response to comments. We are also providing written documentation in the form of an expanded EAF. I'm working with Kristen O'Donnell on that to put that together. I hope, you guys have kept me a little busy this week. I'm going to try to have that to you as early in December as I can with a red line to zoning amendments, some recommended changes. Some of it's fixing typos, things like that. Others will be as the basis of this conversation. Okay, no decision's going to be made tonight, obviously. So I still have homework, but I need your input to do that. So with that, I'm going to switch gears.
I have questions.
Okay, fire away.
So, in summary of all the cases and all the legal jargon, that is very well written out in all these slides. In summary, it is your belief that, per all the study that you've done and all the cases that you've listed, that it is well documented that, religious use needs to be allowed in a residential zoning, AR3 being a partially residential zoning.
In the state of New York, absolutely.
Yeah.
I have not found a single case where a broad prohibition district-wide was upheld. I have seen, and again, there has to be that balancing test. And it's hard because your underlying local law as well as the comp plan don't have that record. So I don't see a balancing test. I don't even see the seeker analysis, which is part of the process. So there's no, and again, there are sites in the AR3 where a religious institution fits in perfectly well. I think the Belleville community is prime example. It's part of the community. It fits in. The main facility is set way back off the road, right? And there are other spots that it may be entirely inappropriate. But a blanket prohibition on all of that doesn't provide for that analysis that is required by both New York State case law and RLUIPA. And I think we have tried to mirror the case law, and I have spent hours researching. I think this is as tight to the law as you can get.
Why would there be, in your play devil's advocate with yourself, why would there be a sentiment that it is not necessary to add religious usage to all residential districts in a town?
I couldn't make that, based on the case law, I can't make that argument.
I had a follow-up to that. 1 second. Damn it. All right, I'll go back to that.
I also had a colleague, one of the things lawyers do is we pick brains of our colleagues. I've called both your counsel and also spoken to other counsel.
You've spoken to the planning board attorney
Dominic and Elise.
and the zoning board attorney.
Yep.
And have you spoken to anybody
and
else?
other colleagues. One colleague advised me that in the absence of any regulation, because of the strength of the case law, that arguably you are giving them carte blanche because they're going to get their religious use anyway. But if you don't have regulations on the books, it's unregulated. So
So
we've
if we
tried to
ju-
put regulations on the books.
Just to restate that. So if we do not, let's say we do not put religious use in the zoning tables, you basically in effect are allowing them to do whatever they would want, whoever they would be in a zoning in a given property, because there's no regulations. But with putting it in the zoning tables and then adding on those special permitted use regulations, you are thereby protecting the town from
The
carte
courts
blanche or
would give
whatever.
them the religious use. The courts would give them the religious use. And because there's no regulations for them to fall back on, you have nothing to fall back on.
Mhm.
So you're going to get the religious use by court order. But now if we say, okay, you can have religious use subject to these regulations, you have those in place. Yes, you have it. You've complied with the court. And you're also going into that site case by case analysis, that balancing. And what are the real impact? What are the impacts, right? What are the true impacts? Lots of municipalities have gotten themselves into trouble because they broadly say, oh, that'll adversely impact open space. Is that really the impact? You have to, the document just can't be there's an impact. there has to be substantial documentation. It's got to be clear. There should be, if you think there's a traffic impact, there should be a traffic study. Show us what that impact is. Again, the case law is, this is about, and I've been doing this now 16, 17 years. I'm always nervous when I go, this is the answer, because it's never, this is the answer, right? This is one of those rare instances where every single solitary case I have found has said the exact same thing.
And there is I saw in some of the public comments that were submitted written, some had cited something that,
I did review those cases. I reviewed any case that came.
No, if you can just, the county planning department, there was a citation of some, a figure there stating something. Have you received anything else? Or have you reached out to the county planning department?
What was presented in one of the comment letters was something that was attributed to our Orange County Commissioner of Planning, which is a fairly straightforward statement on Ray Lupa. Okay. And the commenter had noted that it was for the proposition that all, you don't have to have religious uses in every district. I think that was taken out of context. The Orange County Planning has, in their comment letter, has clarified that statement because it did reference the Commissioner of Planning.
Can you read that statement, that clarification?
Yeah. As the County Planning Director has clarified, the Religious Land Use and Institutionalized Persons Act, that's RLUIPA, requires that any land use regulation that imposes a substantial burden on the exercise of religion must be justified by a compelling government interest and serve as the least restrictive means of furthering that interest. The town's legal counsel is best prepared to interpret the law as it pertains to the zoning code. County planning agrees that the inclusion of religious land use in the AR3 zoning district is appropriate, given the amount of land in the town of Chester included in that zone.
So they've clarified that statement to basically say that your take on this whole thing
Right.
is correct.
I think, and what the commenter was presenting was a broad summary of Ray Lupa, and certainly I didn't find any inaccuracies. I think that they were focusing on a portion of that without the broader context. And so again, we also have to remember that it's not just Ray Lupa as well. It's the New York State, which far predates
The common law.
the New York State common law.
I have two questions that you were not here for the history of, but it's been brought up and I feel compelled to bring them up. You mentioned in the beginning of your presentation that the religious use was taken out of the zoning tables and the zoning code in 2017. Given all of your history, your research on this subject and your ironclad opinion and belief and all of your colleagues.
But anyway.
Well, you said that you believe that this is very straightforward. There is no other answer. There is no way to argue against yourself in this sense. After all that, the town still apparently took it out in 2017. How is that? How are they able to do that? And I guess is it a situation where
I certainly think it's procedurally suspect. It's procedurally and substantively suspect. Lots of municipalities do adopt local laws that do not conform to the law. If
the state law,
the state law or
The
federal
federal
law, it happens all the time, and that's one of the reasons we have a litigation system. Is when a local law that violates higher up law, or even an application and a decision violates state law, we have a process to challenge that, and it happens all the time.
how would that relate to home rule? A lot of people would, in that sense, bring up home rule in the sense of our local laws sometimes do outclass the, the higher up. If you can explain that to everybody.
Well, the courts have said, so just to, yes, there's home rule, but here the courts have preempted that pretty routinely.
Explain that statement. What does that mean, preempt that?
So
Lawsuit, you're gonna lose
our,
Well,
our home rule, the basis of our home rule is inherent in the police power. And this is where I turn into a legal nerd. Okay. And that.
remember you're talking to layman.
Okay. The underlying principle of the police power is that a local municipality gets to make laws and take action in furtherance of you hear me say it all the time, public health, safety, and welfare, public health, safety, and welfare. Okay. What the court has ruled is that the exclusion of churches or religious institutions and schools from residential zones is not in furtherance of that public safety, health, public safety, and welfare in and of itself. There might be situations where in a particular location, in a particular circumstance, it is not in having a religious institution in a particular spot is not in furtherance, and that's the basis for denial. But it is not the basis for an outright exclusion from a residential zone. Okay.
So in summary, it is your belief that whatever the town did to take it out in 2017 is suspect and it could have been challenged this whole time. And it's just that it hasn't been challenged
Correct.
up until now. But it's your belief that if it was challenged, we probably would have lost that battle in court.
Mhm.
Okay.
Yes, absolutely.
And with that, before they took it out in 2017, they had it in the zoning table. The religious use was historically in the zoning table for AR3. There was none of these proposed special use permit regulations that you are, you and Kristen and everybody.
There were limited regulations, and again, those are in 9829. And if you go look at on the town's website, when we did the zoning, we created red lines so people could see the changes. There were individualized restrictions for religious uses. However, there was not the broader, how do you go get the permit? They were kind of just floating out there. So was it special permit? So it wasn't, what was not clear is the ability to impose conditions, that renewal provision I talked about. So that heightened level of review was not there. There are just these kind of floating extra churches shall do this. So there were some restrictions, but not the process to really implement them.
Okay. There was talk about when the previous owner sold it, and apparently there were promises made and there were speeches made and at town board meetings, and everybody was there and everybody saw it, and they said that it was in the deed restriction and so on and so forth. You claim that you've looked through.
I have gone through the land records, as has Linda. We have not identified. The only restriction I see is the conveyance to the town of Chester as part of that subdivision. Remember that open space that they conveyed? That was, I think, 2015, somewhere in there.
There was can you point that out on a map, like what you're talking about there, conveyance?
The only conveyance I see is this piece. Oops, sorry. Hold on. The conveyance of this piece to the town. That's the only
thing that you found in any of the records after everything.
That's on the Orange County land records, and they're publicly.
So when you say that, is that town of Chester records or Orange County records?
Orange County land use records.
But you've also looked through everything that the town of Chester currently
I looked
has.
through the entire planning board, ZBA, and building department files over the past year.
You mean you've looked in your past year? You've looked through all of the records dating back
Yes.
until
Yes.
the beginning of
I have
time.
had my elbows up to as far as you can imagine in those boxes.
My last question that I can think of at the moment is there was talk of having an environmental impact study done on the change in general. What would this change mean to the town as a whole? Because yes, I know there's a lot of people here today concerned about this specific property, but this obviously change would apply to AR3, which you pointed out was near 75% of the total land mass of Chester. That's the majority of our land in Chester is AR3. So what is your thoughts or opinion, or if you don't have one right now, that's fine. But
So
do you have an opinion on what that would mean for the town of Chester to do an environmental impact study?
So typically, again, going back to my discussion on the seeker, the board as part of its job, because I'm going to make you guys do seeker, unlike before. You're going to go through that analysis of what are the impacts. Now, where there's a zoning code, and there can be any number of things that drive a zoning amendment. Where a zoning code is broad in scope and we don't have site-specific projects, we may not do an environmental impact statement, waiting for the site-specific projects to do that. Again, this board's still going through what are the impacts. If there's an impact, and you may not do what's called people use the term environmental impact statement. That's a term of art and a formal term. Often, if it's a smaller impact or a very narrow impact, the board can address it through what we call an expanded EAF, which is an addition to the seeker forms that we already do. Kristen and I have actually already started an expanded EAF to address some of the lower level impacts. So we can review that, and if the board's comfortable, move forward with that. If not, you would declare a positive declaration and do an impact statement. The hard part is doing an environmental impact statement when you don't have specific projects. Now, sometimes there's a zoning amendment. Developer comes in and says, I have this great project. I want to develop this, I'll use one, a TND, a traditional neighborhood design. And they've got this whole plan, and they come to you and they say, this is the zoning we want you to consider. There, you know, a project is coming right behind it. And that is absolutely if the scale and scope warrant, and usually it does, an environmental impact, because you know exactly what's coming behind it. In this case, we have no indication of any expansion, just a continuation of the use that has been there. Again, we can evaluate that as a board, whether an impact statement. My initial reaction is since the vast majority of this code is actually downzoning and creating restrictions, that it will not create those impacts to warrant an impact statement at this time. That does not mean that at a future application shouldn't undergo an impact statement. They probably should, with details and specifics and location and.
Okay.
Okay. All right, should I move on to the next questions?
Let's get to the meeting.
Okay.
Is the are all of the comments posted online yet, or you're still reviewing all of them and they will be posted?
I think Linda has posted everything that came in during the public comment period. My response to comments is still a draft document. When that's finished, I will release that.
But everything that was submitted prior to that cutoff date.
November 3rd.
Anything
Up through November
Yeah.
3rd.
And I will say, we did receive comments after. They're not going to be incorporated in the record, but I did peruse them
Right.
anyway. Most of the comments that we came in after were repetitive of existing comments. So I think you're going to hit all the points. There was nothing that was like, oh, this is a completely new comment. The only thing that has come in since then, which is not subject to that, is the Orange County 239. That came in today.
That will be included for everybody to see.
That's going to be posted on the website.
And
yeah.
that's just for reference. That's what she just read earlier. That's only a part of what she just read earlier.
So I'm going to try. It's now 8:20. I'm giving myself till 9:15 because then we'll lose productivity. So I'm going to try to, and then we'll cut it off so everybody can have an evening. And if I need more, we'll schedule a second work session to go through some of those. Okay. So my first comment, we received a letter from the chairwoman of the Chester Advisory Council, Conservation Advisory Council, excuse me. there were a number of recommendations, but specifically, and I think the ones we want to focus on is,
Bless.
she asked that we add considerations for the Chester Advisory Council into the implementation matrix of the comprehensive plan. Did everybody get a copy of that? Did you see that?
Mhm.
Does anybody have thoughts on that? What would you like me to do? I think Larry, you're on the,
I don't recall seeing that, but
okay, here.
is that a chapter 13? Is that, states the
That,
goals
your
of-
table at the end, that
Yeah.
you have your matrix here, I can give you a
Okay.
copy.
Unfortunately, we're not doing public comment today, but
I told you earlier, I was not aware until yesterday, that there is a cemetery on the property, I was informed by one of the owners.
I know you, but we spoke about it or before the meeting.
But does she know? It
Yeah.
wasn't in the comments.
I'll speak to her after the meeting.
That would be part of a site-specific review of any project. So if there's existing SHPO, and SHPO's the State Historic Preservation Office, architectural, all that stuff is part of a site-specific review.
Okay.
Okay.
If a project were to be proposed.
If a project were to be proposed.
Okay.
Okay. So I don't necessarily have any objection to adding these to the advisory council. I don't know necessarily that they're needed. The Conservation Advisory Council's role is set forth in the statutory authorization. Certainly, if we have the council and you wish to use them, I don't think it hurts unless there's something crazy there. So I just need direction from the board whether you wish Kristen and I to make that change. Okay. So perhaps, since Larry's just seeing this now, maybe Larry, just shoot me an email whether you think we should add that since you're sitting on the committee.
Okay.
Okay.
It makes sense. I don't have an issue with it.
Okay. All right. I do want to go through the county, Orange County Department of Planning has issued advisory comments. These are advisory and then an indication that it's local determination. Most of their requests for changes are focused on the comp plan. And I think a couple of these are low-hanging fruit that we can take care of relatively easily. First, Chapter 3, Natural Resources. We advise the town to revise Recommendation 6 to read as follows. Wetlands shall be delineated by a qualified professional and incorporated into the site plan or subdivision plans where there is a reasonable likelihood of wetlands on property. Where wetlands are to be preserved on a site, they should be clearly marked in the field prior to construction. And the planner noted, we suggest this in the event that the New York State DEC mapper tool becomes obsolete. I think she's just broadening it so it's not just the mapper tool and just where you think there's wetlands, regardless of what the mapper tool. I have no qualms making that change. Is
I
everybody,
also don't.
everybody good? Okay.
Yeah.
Chapter 7, the town of Chester is noted by the New York State Department of Transportation as having a complete streets policy, though the policy itself is not available on the website. This policy should be referenced as part of the comprehensive plan and should be incorporated into recommendations 34, 35, and 39. So that's the first part of that comment. The second is the town should substitute non-motorized transportation in place of pedestrian and bicycle whenever the phrase is used to be more inclusive of other means of transportation. I don't think anybody has an objection with that minor change. Okay,
No.
that's easy. In addition, in recommendation 40, we advise the town to have easements recorded along roads for non-motorized trail options. I can certainly add that. Where somebody, if they're doing a development, would give us an easement along the frontage, essentially for either a bike lane, a walking, in
For
addition
the future.
for the future.
That makes
long-
sense.
Okay, I can add that as well. And going back, the complete streets policy.
I'm sorry, what?
Do we have a complete street policy?
So according to the comment letter,
I don't think so.
I think we need more research into that. So Linda, I'll coordinate with you. DOT is saying we have one. We adopted one at some point.
Okay.
Complete Streets is a program regarding the intermodal of streets and like that. And if you can search it, it's a well-known program in New York State.
Okay.
So
And maybe it was adopted years ago.
Maybe it was
It's not
adopted
we're
years
familiar
ago
with.
and it's disappeared. We might want to revisit that. So I will do more investigation.
I've received a bunch of comments since I started running for councilman to have more, bike accessible lanes along roads and such. So I'd be interested in seeing that added in.
Okay.
Guys, if people are having conversations in the back, I just ask them to move out to the front of the building so they can have those conversations. I'm sorry.
Chapter 8.
Not going to call anybody out.
Chapter 8, we advise the town to rephrase recommendation 45 as follows. Assess potential impacts of proposed developments on town infrastructure, and where a development requires expansion or improvements to town infrastructure, work with the developer to mitigate the impact of the proposed development in such a way that the town does not incur undue financial burden. I.e., this is effectively opening the door to impact fees. So I think it's a strong suggestion, and I don't have any qualms. Is
I
everybody
agree
okay?
with that.
Okay. Okay. Chapter 9, economic development. We advise the town to consider a broader range of industries for support. Tourism, hospitality, and recreation are industries that the town already has and supports. Supporting a broader mix of manufacturing, professional services, and other industries will do more to strengthen the economy in times of recession. Specifically, in recommendation 56, we advise the town to impose conditions on auto-centric uses without prohibiting them entirely within the commercial districts. In recommendation 57, the creation of design guidelines, we advise the town that such programs often do well when paired with decreased regulations or approved burdens. For example, a project in the LB zone could be subject only to a building permit if it was designed in accordance with the design guidelines, where a project in the zone that did not meet the guidelines might be subject to site plan review by the planning board. You may consider such programs. So that's just a suggestion.
Can you explain what the suggestion in just broad terms?
So
is?
if you have design guidelines, which is separate and apart from your zoning, and that again, they are what they sound like. They're designed to regulate architectural standards, proportions, things like that. We are not touching design guidelines right now, but the comprehensive plan is a longer term, broader document. So you could have it in the comp plan, but not touch it now. You would want to hire a professional to write, somebody that specializes in design guidelines to do that,
Well,
do that writing.
Can you define auto-centric?
Auto-centric is uses that tend to that have more vehicular traffic, strip malls, as well as, and then also the comprehensive plan. Let me just pull this up 1 second.
I'm not sure that really conforms to the.
Let me just. The board has the plan eliminated. Give me 1 second because I don't have the bulk tables printed out. I have a lot of windows open. I'm sorry. So that's not going to show me. We removed a number of uses, and I'm trying to find my red line, which I'm not finding instantly.
I guess my overall thought on it is that I would be opposed to putting this in for now until
Okay.
we design the guidelines and
It could be
everything.
a
So
follow-up.
Okay.
Yeah. or part of the
Okay.
recommendation.
We did eliminate, and I was trying to pull it up, a number of uses which were included in the comprehensive plan. And I was trying to find my red line, and I'm not finding it instantly, and I apologize.
It's on your website.
No, not that red line.
I'm sorry.
An earlier draft, so I can. That's the folder I want. was in the LB district. I know that, and it might have been in one other district. Bear with me.
What are we looking for right now?
I'm pulling up current versus proposed. Just so you can see what the auto-centric uses that were removed.
We can do this later. I mean, we're not gonna put it in for now, just to save time.
Okay, I'll send you a list by
Yeah.
email. Okay. Chapter 10, Sugarloaf, we advise the town to consider working with property owners to develop off-site parking in a walkable location. That's an easy one to add. That's
Yeah.
not a legal,
Mm-hmm.
so is everybody okay with me
Yeah.
adding that?
Yes.
Okay.
Yeah.
Yeah.
That's top priority now that we got the sidewalks done.
Recommendation 86 looks at designating scenic roads and creating associated setback regulations. This is not in the current zoning. We advise the town to ensure that this policy does not impose an undue burden on property owners along scenic roads. So that's a follow-up issue. Okay. They made one small comment, which I will take care of. That's a typo. That's a organizational comment for the zoning code. Okay.
They don't go into what they think undue burden is, do they?
No, they just tell us to evaluate it.
Evaluate. Okay.
But since we're not implementing that recommendation right at this moment, we
Yeah.
have some flexibility in that. Okay. Public notice, one of the comments wishes to broaden the usage of public notice signs. That's one thing we implemented. That's one of the practices that's more common down in places like Westchester, but is often great for folks. You put a sign out, for certain size and scale applications, you're required to have that sign. We talked about that before we implemented. The board authorized me to go ahead. Right now, there is a cost to signage. It's not inexpensive to get those signs made.
It'd be the burden of the applicant.
Right. But what you want to avoid is a situation where, a mom and pop shop is coming in for not a very big site plan amendment, right? Where there's no real impact. To balance that, what I would suggest we do is modify that language because right now it only applies to special uses. I would recommend modifying that language to include an application where there was a positive declaration, which is a finding that there is an adverse impact, a potential adverse impact. That way you kind of balance the, because again, if you want to encourage, particularly in places like Sugarloaf or other places where businesses are swapping in and out of existing spaces and you want to encourage that economic base, you don't want to necessarily run up the costs when there may not be a very large impact. So we tried to narrow it to the biggies, right? Special use permits. And then I think a pos deck is a nice way of doing that. Hey, this project potentially has a big impact, so we're going to make you have a sign. And I think that's relatively straightforward.
I'm in agreement with that.
Yeah.
That seems reasonable.
See, now I'm gonna,
I know that's been talked about for quite a long time.
Yeah.
Here, getting that changed. So
okay. Buffering. I'm gonna comment, is Tracy here? Yeah, she is. She did a great job going through and finding inconsistencies. And remember I said you will always find an inconsistency? She did a pretty good job. So your bulk tables, there's two regulations relating buffering. Generally, your buffering standards are in 9819. That's the text of the buffering standards. But also some of the recommendations that came out of the comp plan committee added footnotes to the proposed bulk tables. And Tracy dutifully found that there were some inconsistencies. So we should find a landing spot on that. So now I'm gonna give me one. I should have printed the bulk tables. That's my fault. I'm really sorry, guys.
Question I have is, you eliminated inconsistencies, but what were the differences? It'd be interesting to know what the differences were.
That's what I'm pulling up for you,
Okay.
Larry. Give me 1 second. There it is, documents for public release. And I apologize, at my office, I have like multiple screens, and when I'm on a laptop, it's slightly harder. So let's do the LB first. You'll see in the LB, there's a footnote, a landscape buffer of an area of 100 feet will be required for all such uses adjacent to residential districts unless they are along a state highway. So that was a footnote. And then there's a number of standards, some addressing specific uses, but 9819B, a side or rear yard shall have a minimum depth of 50 feet, of which the first 25 nearest the residential district shall be planted with a screen of evergreens having a uniform height, and goes on there. Any other LBs?
So you change it from to what the table to be what's in the town code?
No, I'm not necessarily saying that. I'm saying we
Oh.
just need to we need to conform the two or reconcile the two numbers.
Right.
One thing I can do is, let me just see, is there a specific? Give me 1 second. And the footnote really only applies to the table I got out of the committee only really applied that to one use. So maybe I just clarify in the section 119, unless otherwise directed by the code. I think that solves that
Yeah.
specific one. Okay. The I and the IP. You have a buffer here on the bulk table where it adjoins the air. So all your residential districts, there shall be a vegetated buffer of a minimum of 150 feet from the proposed use.
Yeah.
And then your other code, and this is an inconsistency, a side or rear yard adjacent to a residential district shall have a minimum depth, width or depth of 200 feet. First 50 feet shall be planted with screen of evergreens.
Right.
So I can increase
Yeah.
to the 150. Does anybody,
Yes.
No, that's good.
if you need 200 feet, if you need a yard of 200 feet, you can have. Okay. All right. See, this is the boring part. I'm sorry. But this is, like I said, kudos to Tracy for finding all this. Same with I, that has a smaller standard. So I'll go with the more strict standard of the 150 and clarify that. Before I do anything, I'm going to circulate a red line to all of you guys
Sure.
for review
Yeah.
and comment, just to make sure. So you'll still have an opportunity to, we hadn't touched buffering other than the footnotes on the bulk table because it wasn't truly it wasn't listed as one of the goals of it wasn't one of the priorities of the plan. So I didn't really touch this particular section, but I don't want to adopt bulk tables that The last thing you want is an applicant saying, okay, so which standard applies? I'd like to have a consistent standard. Tracy asked, there's no footnote in the GC. I eliminated the footnote because it just sent you back to 9819, so it didn't do anything. So I just eliminated it. I hate footnotes, so the fewer footnotes, the better. Okay, I know, and this was a particular bone of contention with a recent project. Your code describes adjacent properties. Does adjacent properties cross a street?
I'm sorry, say it again?
So if the project is across the street, do the buffering standards apply? Do you want the buffering standards to apply? Yes.
Yeah.
How big, now I'm going to make it hard. How big of a street?
Shouldn't matter.
Well, what if it's on the other side of 17?
That's a highway. That's a highway.
Okay. You don't have anything larger than 2 lanes.
No.
Anyway,
Not in the town of Chester.
not in the town, in the village.
Not unless you want to consider town road, county road, or something like that.
All right, so across the street counts as adjacent.
Yeah.
Okay. Okay. I will make that clarification. Okay. We did receive a comment from the Comprehensive Plan Committee regarding agritourism. I had no issues with the committee comments. I'm going to make those. The one thing I caution you, having done this in another jurisdiction, you may want to clarify what one of the things with agritourism is wineries and breweries. You may want to clarify that that is craft and define it. Otherwise, you might have a farm with an Anheuser-Busch. And I don't think that's your intention. I think you want mom and pop farm. They have a little vineyard. They grow some hops. They have a small brewery. We have lots of, small scale penning cidery type thing.
Makes sense to qualify.
Yeah.
Okay.
Matt, Tracy, does that kind of
That makes sense.
with the,
You didn't
Yeah.
consider,
And it actually ties into the New York State Liquor Authority because there's different tiers of licensing.
great.
So-
If they've got the tiers, then
I'm tying it into, I would tie it into the tiers. And it's and there's a limitation on scale.
what's environmental online, not
I got it. Understood. I think I can accomplish that. Okay. So that's I'll make that change.
Good.
This was a planning board recommendation and it was a great recommendation. The text of your zoning code, which is in 9811, discusses customary residential uses, and then your bulk table also says it. I like the text better than the bulk table, but you tell me which one you like. Customary residential accessory uses include greenhouses, garages, sheds, tool houses, playhouses, wading pools or swimming pools, sports court, all incidental and subordinate to the residential use of the premises and not operated for gain. That's in the code. The table is customary accessory buildings, including swimming and wading pools, not operated for gain, private garages, sheds, storage building, or car park. I like the first one better.
Yeah, I like the text.
You like the top one. Larry?
It's more definitive.
Yeah.
It's the incidental and subordinate to and operated. The
Yeah.
last thing you want is somebody who has a small single family house, and they come in and they put a full-size basketball court with bleachers and everything else that's bigger than the house.
yeah, more detail is always better than less.
Okay, so I will go with the first.
Liz, one of the things the committee talked about is an accessory uses to make sure that they're not constructed within an easement, like a utility easement, a drainage easement. 'Cause that frequently happens. Is there any way to make sure that type of verbiage is in there?
I think I put a regulation in, but I will make sure it's certainly part of site plan that you have to identify the easements and no
Okay.
construction, but I will add it. No, I'll add that to the text of the code. Again, I hate footnotes.
That include water and sewer lines also?
Yeah, any utility easement.
But even if it's private homes, like you don't want them to build over top of their sewer line or on top of their
Right.
water line with something, some type of
Right.
permanent structure that would not allow them to replace that line in the future.
Well, the risk is if they do it, then they're going to have to wreck their whatever. You know, so there's some onus on the property owner to make sure that they're not installing it in a bad
Typically,
spot.
house utilities is in the front yard. typically.
Yeah.
So you can't put a building like that in the front yard anyway.
I can clarify that more.
They have no backyard.
Okay.
Well, the town code doesn't allow it in the front yard.
Nothing in variance.
And the variance would be given,
No.
Okay.
Even if you have a hardship and no backyard.
that's release.
One of the, and I don't remember if this was the comprehensive plan committee or somebody else, so if I misattribute it, my apologies. Your clustering language, and that is 9825. I think there was a comment that there wanted to be a greater involvement of the town board to review open space at a broader, to enable enable broader oversight of that. I certainly don't have an objection to the the town board having a role. I caution that as a town board, and actually NICOM is the equivalent of Association of Towns for Villages and Cities. The one attorney there he's like, don't let your village boards and town boards, your legislative boards have planning authority. They're legislative. Let the planning board, let the planning board. So that I can hear him repeating that in my head. Because it makes a planning decision a political decision instead of a planning decision, an impact decision.
Our comprehensive plan chairman had a,
Yeah, I believe this was feedback from the comp plan committee.
I-
And I believe we were commenting on some existing language that was underlined.
So I'm trying to figure out which, I can certainly add, that, a proposed open space is subject to approval by the town board. That's, but I don't want to necessarily bring you into because I'd rather let the planning board do their planning. Where is the appropriate space? How you treat that open space, HOA, conservation easement, or fee dedicate, land dedication, that can be a town board issue. That can be a town board, but I don't want the where.
How we would prefer to see it done.
So form yes, where no. Does that make sense?
Mhm.
Okay, so is everybody okay with me adding that? Okay. Okay. Battery storage. We got a couple of requests that we do additional research. We effectively took the battery energy storage local law was modeled largely after the New York State recommended local law and NYSERDA local law, which is a model local law. If you have concerns, you might consider temporarily pulling that out and adopting that as a separate standalone issue. You could do that.
Is this strictly commercial or all?
It regulates all. It's a tiered approach. It's if you look, Larry, it's the last. We added one last article. It's a brand new article at the end, so
Okay.
that one doesn't have a red line.
Yep.
It has a 1, 2, 3. Excuse me. 1, 2. It has a 1, 2. your ones are your battery packs that are typically in residential settings. Storage backup. If you've got solar panels on the roof, there's a battery backup for use of that energy at night. I don't think we're necessarily worried about that. You're looking at the larger
It'd
systems.
be nice to have something on the books right away.
Yeah,
Yeah.
I
Okay.
feel like we've spent a lot of time going through all the
Okay.
provisions.
You have certainly seen it. It's something.
Yeah.
I also just,
I like
again,
that
this
idea.
is one of those areas under the law, and the reason that that folks have been adopting moratoriums is that absent regulations, there is discussion in cases that it would be treated like a utility, and utilities have very little regulations because they're broader to serve.
We
And
need
you don't
something.
want somebody coming in and saying, guess what, it's a permitted use because it's a utility, when you want specific regulations.
We've had a moratorium on the books for this for almost 2 years now. I don't,
Yeah, 18 months, yeah.
so like,
Okay.
I feel like we've spent a lot of time going through all of it.
Okay. Any-
You've read into the comments more than anybody else, maybe other than Larry. What were, I guess, in your opinion,
The biggest concern, and I understand the concern from folks, is that, they hear the news and there were two.
There's concerns.
That's why we put in the
Yes.
moratorium, the
Well,
fires.
there were two fires. Again, all these projects have to undergo a site-specific review. That's the intent, to include it. The fire department would be included. I'd encourage you all to look at it. We certainly tried to cover all of those issues and response plans and things like that. And there are provisions in there, to have that kind of stuff.
The primary concern is how to fight a fire. Yeah, the safety.
And most of those actually, and again, this is where you want to involve your fire guys. And people freak out when I say this. The answer is let it burn. And people go, oh my God, that's the answer. But again, part of the submission is they have to provide an adequate response package.
Yeah.
An emergency response package. So there's a whole, if you look, the emergency operations plan alone, just the requirements take over a page.
I know I keep on breaking my own rule, but they are part of the comprehensive plan
You were-
committee. Did you have something to say on that, Matt?
Yeah, I think we talked about this extensively, and I'm sure we've done the research on the law and what you put in. But the intent, and Larry, Tracy, correct me if I'm wrong, but our intent in the plan was, we want to just say no on this until it's fully understood. And I don't want to put a date on when that's fully understood, so I do appreciate Liz's view that it could be treated as a utility. And perhaps then the thing is to say, we just aren't doing this for them. Separate from putting a boundary wall on your house, that's sure, that's.
I don't know that I can keep a moratorium going indefinitely.
Why don't we just put it in code? We can't do it.
I'd have to look more into that. The recommendation was to include, we were talking about this from the beginning, so
You can't
Yeah.
ignore it.
I don't want to ignore it. I'm
You can't
personally.
ignore it.
we have a little bit of time. I can shoot you all an email on that. But the answer is not to just leave the moratorium in place. That would get you in some trouble.
I mean, this technology's coming, it's gonna happen. And we talked about in the committee, about we don't need to be early adopters. But understand it's gonna be.
Maybe suggested too, we haven't talked to the fire department on what's their attack plan if they come across something like that. Maybe,
Did we not?
I don't think they have.
I feel like-
It's been the same concern they have with electric cars.
Yeah.
They deal with it in the same way, only on a broader scale.
I'm on the other kind of side of this. I'm not sure.
You might also, a great resource, call the Association of Towns. They've been dealing with this all throughout, and they have those resources. That's why you are members of an organization like that, and they can provide you. Just call them up and say, hey,
Guidance.
what's your guidance? What guidance are you seeing? Trust me, they have a file, and they will hand you a file on various issues. So don't hesitate to use that resource available to you as part of your decision-making process. Okay, I'm going to move on. I'll put a pin in that one for now. I'm almost through this, so I might, okay. Change of use. We have had a lot of conversation of, and again, this is going back to Camp Monroe. This isn't a specific to Camp Monroe, but I am recommending a slight change to the, I offer a suggestion to the site plan language. Typically, if a change is minor, one shop going into another, it would not be a change of use that would trigger a site plan review. No construction, no real impacts. You're not altering the site. What I would suggest, if that it is a change of a seasonal use to a year-round use for anything other than a single-family home on a conforming lot, that it be subject to site plan.
That'd be what?
Subject to site plan.
Yes, I agree.
Yeah.
Okay. Is everybody okay with
Yeah.
that?
Yes.
I think that's a great compromise, and addresses some of the impacts.
They have to go through all the
Yeah.
stringent process of, you know.
It's not even, the Camp Monroe specifically. I'm going to pick on some of your neighbors. Greenwood Lake has a lot of seasonal bungalows from the 20s. Some of those septic systems, they're barrels with holes drilled in them. They're not much there. Like you think I'm kidding.
I've replaced a lot of them.
So, and then you get folks that move, want to say, oh, I wanted a year-round home, and then it turns into a $60,000 septic system.
Everything around that used to be.
So,
seasonal, now it's all
we've got
year
that,
round. Causing issues.
up in Sullivan County, they're old bungalow colonies from, again, the 20s and 30s that they shoved stuff on, 50 by 100 lots and with a septic system. So there's a lot of stuff that you don't want to necessarily just say,
So
oh,
by
yeah,
doing it, you're covering a lot of ground they have to update a lot of things if they want to increase the amount of time that they're there.
And this is really to, you have to be careful with seasonal. Again, what is seasonal? And I'll probably include in my red line
We can
a
clarify that.
revision,
Yeah.
a definition of
That
seasonal.
needs to be clarified.
Yep.
Please, for please.
Winter seasonal or summer seasonal? I could go down that rabbit hole. Okay, we're getting there. This is a teeny tiny nitpick, but this is actually, this is how zoning codes change. Just to give you an idea, somebody gave your ZBA chairman a call about multiple uses on a lot. He called Elise and said, what's the answer? Elise called me, and then we had a discussion, and we said, we should revise the zoning code so you can kind of see where we're going. So we wanted to, 98-6 is the effect of the zoning code. And so you can see the proposed red line. No yard, open space, or open space required in connection with any building or use shall be considered as providing a required open space for any other building on the same or other lot. I wanted to just clarify and broaden it so that there was no confusion and no wiggle room and no room for shenanigans, that it is the building or the use, because sometimes uses don't have buildings or outside, and that it was all of them. It was the yard, open space, minimum lot area. So I think that's a technical revision, but I think it's an important one. If you're going to have 2 permitted uses on a site, you need to have enough space for both those permitted
Agreed.
uses.
Yeah,
Okay,
absolutely.
I'm at my last slide and it's not 9:15.
Right.
Good job.
Did you take note of that?
Yes.
I've been following along.
Okay.
I've been following along.
Do you have any questions? This is not, I want the public to be clear. This is not like, oh, these are it for the public comments. These are the comments I think I needed the board's input
Guidance.
on. You will be getting from me, and it's going to be after Thanksgiving. Sorry, guys. You will be getting from me a red line of the comprehensive plan and zoning Some of it is technical cleanup, some of it's typos, some of it's what we've discussed this evening, but you will see a full red line, and it won't be intermixed with the existing red lines. It's going to be a whole new red line. You will also get a draft proposed, because again, while I'm drafting the responses, they're ultimately your responses, and you have to be, you're authorizing the language, okay, because the response is coming from you. So you're going to get a draft response to public comments. Right now, it's at about 46 pages, okay? You will also be getting a draft expanded EAF so that we can undergo our impact analysis and whether we need, what else we need to include in seeker, or whether we need to take the next steps to an EAF, not an EAF, environmental impact statement. So those are the documents you're going to be getting. Like I said, you guys have kept me very busy this week. So you're not getting this before Thanksgiving. Does anybody have any questions?
Not at the moment.
I just hope with all the changes we're making and everything that we do, that we can have the enforcement as strong as we need it. That's our downfall.
And
Yeah.
put resources into your building department and give your
Yeah.
building inspector the tools to do that.
Well,
Okay.
we'll have the tools. You can give the people all the tools they need, but they
You
need
still
to,
have to
they
do
need
it.
to use those tools and apply them.
Maybe that's where, maybe that's the discussion of maybe code enforcement, to kind of loop in with some of this.
I think this,
Yeah.
I think that
Have a strong,
Yeah.
strong code now.
I'd really
That's
like
where
to
we have
start.
Strengthen everything.
Well, what I think we need, this whole conversation brings up the need for what we've been trying to, we've been talking about this since we took office in 2024. Some of us, is the part-time code enforcement officer.
We're
Working
working
on
towards that.
Yeah, I think having that help in the building department to keep up on top of anything that is out of compliance with our code and the law, we really need to, we need to pursue that.
We need to address the quality of life issues, and when variances and everything are given and there's permits and things that are in site plans, that they be adhered to.
Mhm.
That's our big issue, adhering to what's out there. Because I see it on a site next to me. They basically do whatever they want. They as soon as they got a site plan approval, they rip things out, redid things. We have people living in a place that's not, it's like a nightmare.
It's also,
And this is just one small spot. that
I
I'm
have
looking
this
at.
issue. I have this issue right now, and when you do your final inspections and issue that CO, once you issue that CO, you're signing away a lot. So you want to make sure that when you issue that CO, everything is in place. Like, so for example, we have,
as soon as the CO comes out, it's just like boom, they do
yeah,
what they want.
well, the
So
CO
that's where
says that the
enforcement
building's
has to
built
be
in
strong.
conformity. So I'll give you a prime example. Florida today, the village board met. His landscaping wasn't installed, right? It wasn't installed per the plan. He had installed some, but not all. The assigned code enforcement officer, you didn't install the landscaping plan. So they made him post a bond, to a performance bond for the installation. It's too late now. We're in freezing temperatures.
Yeah.
But there's now a performance bond, and if he doesn't do it, the village will. So, but again, once you just say, oh, here's your CO, you lose a lot of leverage.
You bet.
Yes, indeed.
Okay,
Okay.
everybody.
Yes, thank you.
I'd like to stay here for another 45 minutes
Yeah.
with
Um,
everybody else included.
Enjoy.
Enjoy.
I told
We'll
you
go.
9:15. I wanted 9. It's 9:04.
I'll make the
I'd like to
motion.
make everybody miserable.
I'll make the motion to close the meeting.
Second.
We're good to go.
There's a motion, there's a second. All those in favor?
Aye.
Aye, we are adjourned. Thank
Thank you,
you.
Liz.
Thank you.
You're
Liz.
welcome.